Members, this is the appointed time. We have a quorum. So I call this meeting to order. This is the meeting of the Bills Committee on Evidence Amendment Bill 2026. So let's begin. Item 1, meeting with the administration. Would the clerk please invite the government representatives into the room? We're joined by Mr. Llewellyn Mui, Solicitor General, Department of Justice, Mr. Jonathan Mann, Deputy Director of Public Prosecutions, and their team. Welcome. So SG and the team, would please take a seat. The deadline for receiving written public views was yesterday, the 28th of July. The Secretariat has received one written submission which has been uploaded to the Electrical's website, and it has also been forwarded to the administration for a written response. Now, there are matters arising from the previous meeting. In relation to the follow-up to issues arising from the previous meeting, please note the relevant papers. LC paper number CB-3 901/2026-01, which is a list of follow-up actions. The administration's response to these issues can be found in CB-3 901/2026-02. I will ask Mr. Llewellyn Mui, Solicitor General, to walk us through the administration's response. And if you want to ask follow-up questions in relation to their response, please press the Request to Speak button. Mr. Mui, over to you. Very succinctly, I will go through the written response for members. At the last Bills Committee meeting, members made a request for the administration to provide further information on the consideration of the Law Reform Commission back then, when it studied the relevant topic, in particular whether the LRC considered the relevant models adopted in Australia, Canada, and even Singapore. In fact, at the last meeting, we gave a brief response, and we've prepared this written response on this occasion. In short, the LRC dedicated Chapter 5 of the report to a detailed analysis of the models adopted by different common law jurisdictions, including Australia, Canada, as well as England and Wales, as we mentioned a number of times, New Zealand, Scotland, South Africa. So the LRC looked into the models adopted by these countries. Last time I also mentioned the one adopted by the United States. So if we go to Chapter 5 of the LRC report, apparently the Law Reform Commission considered then in great detail the different approaches to hearsay evidence adopted by Australia and Canada. In the end, we note that the LRC analyzed in detail and selected 3 options as set out in paragraph 4 of the paper, and that is the models adopted by England and Wales, the United States, and New Zealand. Having analyzed these different approaches, the LRC has recommended adopting the New Zealand model. So the LRC definitely considered the 2 models adopted by Australia and Canada when considering the matter. At the last meeting, members also made another request. That is, the committee would like to have a detailed tabulated comparison of the models adopted by Australia and New Zealand. And in fact, you will find this comparison in pages 4 and 5 of the paper. So by comparison, we find the New Zealand model more reliable because comparing to the Australian model, New Zealand includes a very important condition in its model, and that is reliability. It's also called reliability threshold in our bill. Members, if we turn to the table on page 5, for the Australian model, we've made it clear for the purpose of comparison that when it comes to condition of reliability, for the Australian model, although the reliability requirement may be embedded in some of the exceptions, there is no general express provision on reliability assessment. In other words, under different circumstances, as far as criminal cases are concerned, for hearsay evidence to be admitted in that jurisdiction, there will be different considerations. That is, in one jurisdiction, there may be the consideration of reliability, but in another jurisdiction, reliability is not something to be considered. So this is a very clear table for comparison, and that is why we agreed to the New Zealand model. As for the model adopted by Singapore, let me very briefly go through that as well. We are of the view that the Singapore model is not something more favorable than the New Zealand model. As far as our consideration is concerned, members will find the relevant details in paragraphs 13 to 15 of the paper, because the Singapore model has a fixed list of specific statutory exemptions, but there is no express reliability requirement. Also, if members could turn to paragraph 15, the other consideration we had for Singapore model is that it relies on an exhaustive list of specific statutory exemptions, and that is similar to the US model. Now, according to the LRC report, they gave very detailed consideration of the matter. They are of the view that this is not a very ideal approach because an exhaustive list of statutory exemptions would make the court impossible to deal with some exceptional circumstances which are foreseeable under the common law. In other words, if we adopt the New Zealand model, we will be able to initiate the mechanism that we propose through the bill, and that is for certain conditions to be met first as safeguards. And by way of this mechanism, we may be able to deal with some special situations. For example, as I explained, there are exceptions under the common law, and there are also other statutory exceptions that cannot be dealt with. And that is why we agree with the LRC that the New Zealand model should be adopted. As for Canada, as we explained in the paper, When it comes to hearsay evidence admissibility in criminal proceedings, Canada relies on judicial development. So that's the approach taken by Canadian courts. However, when it comes to English courts and the Hong Kong Court of Final Appeal, according to case authorities, the courts have expressly declined to follow this judicial approach of handling hearsay evidence through the development of case laws because of the complexity of the issue as well as the point of policy relating to criminal evidence. And we have cited some cases in page 8 or page 7 of the paper. For example, in paragraph 21, the Court of Final Appeal handed down a recent judgment in relation to the Hong Kong SAR and Lee Chung Choi. And the Court of Final Appeal has made it clear that it should be left, the matter should be left with the legislature. The government is fully on board with this view, and that is why we don't think the Canada model is suitable for Hong Kong. So much from me. I welcome questions from members. Thank you, SG, for the explanation. I see that a member would like to ask follow-up questions. Ms. Maggie Chen. Thank you, Chair. Likewise, I'm of the view that the New Zealand model should be adopted because it is based on the court's discretion, but it's not an absolute power. There is a balancing point when it comes to necessity and reliability. However, I cannot rule out that for statutory exceptions in certain litigation, they may be foreseeable. So my question is this: if it's not a statutory exception, and if we're still basing the decision on the court's discretion on reliability and necessity, then when it comes to the appeal process, my question is whether there will be more cases subject to appeal. Right, SG. Thank you, Chair. Thank you, Ms. Maggie Chan, for the questions. I think I understand where she came from. Let me first supplement in relation to this situation. And I also think that when we come to the clause-by-clause scrutiny, we will bring up this point again. Let me explain the bill's mechanism. We are not going to rule out completely all the statutory exceptions. Let me give you one example, and I'm sure that members here understand very well. For the evidence ordinance of Cap 8 of the laws of Hong Kong, there are provisions relating to criminal procedures. And this provision relates to the handling of testimony or written documents being admitted as evidence under certain circumstances. Now, I'm just giving you one example. We have, for example, the evidence ordinance or Chapter 8 of the laws of Hong Kong currently in force. So this is just to supplement my answer. I'm sure Ms. Maggie Chan is fully aware of this part as well. I don't think this bill will affect other exceptions already available in the laws of Hong Kong at the moment. Now, the next point is about statutory exceptions. As I mentioned, under the common law, there are exceptions or exception provisions for the handling of hearsay evidence in criminal procedures. Now, at the clause-by-clause stage, we are going to explain in greater detail for members' consideration. We work on the LRC's recommendation, and through the schedule of the bill, we seek to retain the common law exceptions. So that's the second point I wish to supplement. This bill has made reference to the New Zealand model, but it doesn't mean that we are completely ruling out the statutory exemptions. I appreciate Ms. Maggie Chan's concern. I think her concern is that under the proposed mechanism, the court will be able to exercise discretion in deciding matters relating to hearsay evidence, and whether the court's discretion will result in the case being appealed against. And my response is that is possible, but then when it comes to criminal proceedings, the court will definitely carefully consider all matters under the new mechanism. And in fact, this appeal mechanism has always been available in our legal system in Hong Kong. And we're confident that this new mechanism will not spark further disputes.
Ms. Maggie Chan, I have a follow-up question. Thank you, Chair. Upon passage of this relevant bill, as we follow precedents under our legal system, if we're inclined towards the New Zealand model for the first or second cases, with judges often had to quote previous cases, do you expect judges having to refer to New Zealand cases then? That's my first question. As for the second question, for the laws of Hong Kong, if you anticipate that judges will refer to the cases in New Zealand, what will the judges in Hong Kong inclined to do? Thank you. Mr. Lewalamui. Thank you, Ms. Chan. We noted in the LRC's report, when there was consideration of different models of common law jurisdictions, it talked about in the report different case authorities in the jurisdictions. From the government's perspective, before we introduced the bill to the Legislative Council, we also explored this in depth, including some authorities in New Zealand court, but we referred to cases in other jurisdictions as well. We very much understand where Ms. Chan came from, and your understanding is quite correct. But I would like to supplement some information on this. We would refer to the New Zealand model, but what we have isn't necessarily unique to the New Zealand model. For example, if a witness is not in Hong Kong, and even with reasonable and practical measures, the witness cannot attend court or give evidence via video link, what is to be done? The handling method is not unique to New Zealand. It is also how it is handled in the UK. I do understand where the member's concern lies. Please rest assured we will not only refer to New Zealand's model, specifically the different elements of the model are also made use of in different common law jurisdictions such as the UK, Scotland. With the different authorities, I believe the legal sector would comprehensively refer to the different cases. As professionals, we should not only refer to the cases from New Zealand, subject to passage of the bill by the LegCo. In implementation, I believe the courts will comprehensively refer to cases in different jurisdictions in order to make clear the relevant principles. The judges of Hong Kong should also exercise independent judgment. They don't necessarily have to agree with, say, the Supreme Court of New Zealand on this. Thank you. Ms. Maggie Chan. Chair, I think the Commissioner is quite right. I mean, the Solicitor General is quite right. It really helps make clear where the inherent jurisdiction lies, and we need to make sure we have regard to local circumstances. I think this is important for judges to exercise their discretion. Ms. Chen has indeed raised a very good question. Thank you. Let's move on. Professor Alex Fan. Thank you, Solicitor General and other colleagues of the DOJ, for preparing a very detailed paper to follow up on our different concerns raised at the meeting of 14th of July. My concerns have been responded to. I am quite confident that we can make use of the New Zealand model as a starting point for the reforms relating to the introduction of hearsay evidence. We haven't yet got to clause-by-clause examination just yet, but as the Solicitor General mentioned, we have the condition of threshold reliability being quite different from some jurisdictions such as Australia. So now we have in the bill section 55T paragraphs A to E. I will go into more detail when we get to clause-by-clause examination. I just want to highlight some points here. So 55T to A to E, it provides some criteria and principle for courts to consider the condition of threshold reliability. And I can see the expressions here adopted are quite neutral. But if we look at, say, Australia, so with the Order 65 in Australia, they did not say specifically there is a condition of threshold reliability, but I think the considerations will be quite similar to what we have for 55T2. But for 65(2) of Australia's provisions, they do not adopt neutral expressions. They will be more inclined to think something is unreliable when there are certain circumstances. I think there may be different approaches. I just have a question about how we should express the relevant approach. We can perhaps go into more detail in the clause-by-clause examination. I would just like to highlight this here. Alright, perhaps we can wait until the clause-by-clause examination, and when we scrutinize the relevant provisions, we will have better context. Mr. Llewellyn-Moore, do you agree? Thank you, Chair. I agree. I understand Professor Alex Fan does not necessarily need me to answer a question for now. We can perhaps go into more detail during the clause-by-clause examination. Thank you for his comments. Thank you. Let's move on to Mr. Wu Yingpeng. I believe the New Zealand model is preferred because it is more reliable, and with the condition of threshold reliability, it would highly rely on the facts and the judgment of the judges. Still, I would like to echo on the point made by Professor Fan. I think we should talk about what factors or weighting that the courts should consider. I think we need to make this clear, as we see very different circumstances for each case. Perhaps we should also give some sort of guidance so that there is not too much uncertainty. Thank you. I believe this is also a comment. Let's move on to Ms. Christine Fang. Thank you, Chair. Thank you, Solicitor General, for providing a comprehensive comparison of different jurisdictions' models. I also thank members for raising concerns so that we have a good understanding of the background for our scrutiny. Now, the Solicitor General talked about how the condition of threshold reliability is preferred, and I believe courts in future would want to refer to our proceedings, say what we discussed today, to get a better understanding of the legislative intent. With our comparison of different models, we have chosen a more neutral model. I do agree with this direction. I just wonder if the exceptions will be included in the bill or other guidelines instead. I refer to a document on the Maya case. Why you didn't adopt the case of New Zealand, and the case in Singapore actually talked about how some illegitimate vehicles were received, and it is believed the Legislative Council should legislate for how we are going to refer to the particular case for reference. So I want to ask, in future, when judges make use of legislation in other jurisdictions for reference, will it affect the judgments of judges, or will judges still prioritize the approach of New Zealand? Thank you.
Thank you, Chair. Thank you, Ms. Fong, for the two questions. The first question, as I understand, is that you want to get a more detailed understanding of the statutory exceptions and whether we will provide a list. Now, I think it's easy for members to understand the way the bill is drafted, because this bill comes with a schedule. We will come to that when we examine the bill clause by clause. Our proposal is to add a new schedule called Schedule 2. And then in this schedule, we will provide the common law rules relating to exceptions to rule against hearsay preserved. And there are 9 of them. To echo with the LRC's recommendation, which we agree. So, through amending the evidence ordinance, we will add to the ordinance Schedule 2 in order to preserve the common law exceptions. To answer Ms. Maggie Chan's question just now, in fact, under the laws of Hong Kong, at the moment, you will find provisions relating to statutory exceptions, and they will not be affected. For example, there are provisions in Chapter 8 of the laws of Hong Kong, and that is the evidence ordinance. There are also exceptions available in criminal proceedings. For example, documents commonly used by banks are admissible subject to meeting certain conditions and under certain circumstances. In a criminal proceeding, the so-called hearsay evidence in a form of bank documents may be admitted as an exception. So to respond to your first question, through this bill, we are going to include the common law exceptions to hearsay rule in the evidence ordinance. As for other statutory exceptions available in the Hong Kong laws, we are not going to scrap them. And to answer the second question briefly, as I understand, you said you wanted to learn more about the court's process. That is, in the future, under the new mechanism, how does the court consider admissibility of the hearsay evidence? How should the court make reference to the relevant legal provisions or case laws in other common law jurisdictions? Now, first of all, we firmly believe that the judges are very experienced, and I believe by then the judge in question will be able to handle this point of law. In other words, subject to passage of the bill by the legislature, if the bill becomes new law, a new mechanism will be enacted, and the court must follow what is set out in the bill in handling the matter. In relation to accurate understanding of the conditions set out in the bill's provisions, the court can also refer to the other information such as the LRC report, which sets out the LRC's consideration of the New Zealand model. And then the court will be able to appreciate that our mechanism is akin to the New Zealand model. And as such, the court can make reference to the New Zealand model. But it's only for reference. The case laws in New Zealand do not bind the courts of Hong Kong. I want to emphasize that our courts will exercise judicial independence in considering this legal issue. For example, the New Zealand Supreme Court may have handed down judgment which is binding on the courts in New Zealand but not in Hong Kong. Well, thank you for spelling this out. I think this is a very crucial point, Ms. Christine Fong. Now, I want to ask a further question about hearsay evidence. Now, I came across some cases involving forged signature, and the victim concerned is actually in Australia, and the victim is unwilling to come back. Now, SG, you cited an example. As far as the principles are concerned, say if all reasonable steps have been taken and practical steps have been taken, and the victim is or does not come back, then does it mean that under the new mechanism, the televised link can be used to take hearsay evidence to be admitted by the court? SG. Thank you, Chair. Thank you, Ms. Fong, for the question. Let me take this opportunity to elucidate this issue. One way to admit hearsay evidence, according to this bill, is this. The declarant of the statement is not in Hong Kong. This is one of the conditions, but there is more. We need to consider the so-called necessity condition. Now, this declarant is outside Hong Kong, but there is another condition to be met, and that is for the party wishing to adduce hearsay evidence, they must, well, let's say it's a prosecution. The prosecution must prove that this declarant is not in Hong Kong, and the prosecution has taken all reasonable and practical steps to secure the attendance of this declarant in court to give evidence. At the same time, the prosecution must prove that all reasonable and practical steps have been taken for the declarant to give evidence through other statutory permitted means, such as televised link, and that is not possible. Now, if the declarant is able to give evidence through video conferencing in a remote manner, then this is not hearsay evidence. For example, this declarant may be in Australia, and this declarant may be cooperative, and arrangements can be made. And if this televised link approach is unopposed by the defense, and with the court's permission, this witness can give evidence through the televised link and be subject to cross-examination. So this is not hearsay evidence. The prosecution must prove why such an arrangement cannot be made. It is not sufficient just to say that the witness find it inconvenient to do so. So this necessity condition carries quite a high threshold. Right, the SG just now mentioned the use of a televised link for a witness to give evidence subject to agreement by parties and permission by the court. Then it's called a remote hearing. It's not within the scope of hearsay evidence. Next, Mr. Holden Chow. Right, thank you, Chair. Thank you, SG, for giving a very detailed response. I'd like to speak on the New Zealand model. He just explained why we have made reference to the New Zealand model in drawing up the bill. And I remember during the first meeting, I maintained the same position, and that if we are beginning to admit hearsay evidence, we need to be very careful. The DOJ just explained, and I'm delighted to hear, that the New Zealand approach is actually a balanced approach taking into account necessity and reliability. So there are two thresholds. Now, my next question is this. The New Zealand model has been adopted for some time. So I'll try and see if you can answer me now or later. Since the New Zealand courts adopted this model to admit hearsay evidence, inevitably there might be additional legal procedures involved, such as voir dire or other kinds of judicial proceedings involved. So I'd like to know your observations. Have you conducted any assessment of the New Zealand model since its introduction? That is, by admitting hearsay evidence. For example, have the trials taken longer, or have there been additional procedures involved? I'm not asking for a specific figure, but just your impression, because clearly you mentioned in the paper that this is a balanced approach for the interest of justice, but then you need to consider the prejudice, whether, for example, it will cost the court additional time. So I want to know whether you've conducted any assessment. That is, after years of implementing the New Zealand model, can you share with us whether you have any observations about additional time for litigation or procedures? Right, the New Zealand courts adopted this model back in 2006. SG, thank you, Chair. Thank you, Mr. Chow, for the question. I think Mr. Chow has made a very good point, and we need to ponder it very carefully. We need to follow up on this point as well. Now, at the moment, I don't think I can give Mr. Chow a direct answer. I ask for members' understanding. The member asked for information that, frankly, is not readily accessible by the Department of Justice of Hong Kong. However, I can explain this to members. We find the New Zealand model more robust and more suitable for our laws. And in drawing up the bill, we carefully considered the New Zealand model as well as the important case authorities handed down since its implementation. I remember at the last meeting, some members asked me questions, and I mentioned that in relation to the case authorities in New Zealand, members expressed concerns, and these are legitimate concerns, about the absence of witness and the possible abuse of the system, like Mr. Chow just now mentioned. We noticed that the New Zealand courts made certain rulings in cases in which conditions were met, and the court was satisfied. In fact, we've checked the case authorities, resulting in two different outcomes. And in our response to the LegCo's legal advisor's letter, we have provided a response, and we've provided a table for reference. Now, I'd also like to further explain the issue raised by Mr. Chow about the New Zealand model's implementation. In fact, recently, we've identified a trend, not so much a development, but there seems to be a trend. In fact, there is a study on further relaxing the threshold for admitting hearsay evidence. This is a preliminary development to our understanding, and that the Department of Justice should be very careful in considering how the government of New Zealand handles this issue. So I fully agree with Mr. Chow that we need to be careful. We cannot dive right in and adopt the relaxation proposal in New Zealand. Because even in New Zealand, the government has not given it green light yet. So I fully appreciate Mr. Chow's concern. We're going to do things step by step. This reform will bear great significance to the criminal procedures in Hong Kong.
Mr. Holden Chow, I have just a very brief follow-up, Chair. I thank the DOJ's representative for giving a very detailed explanation. I heard what the DOJ's representative said. New Zealand has made some changes, but we should be prudent. After all, they have been implementing the model for quite some time. If they want to relax the restrictions, they probably can, but we are not moving at the same pace here, so we should be more prudent. Why do I think we should be prudent? As we are in an AI era with the acceptance of evidence. It's not just hearsay evidence. For, say, evidence generated by AI, we still do not have a concrete stance on how to deal with such evidence, so I think we should be prudent. And I appreciate the reply given by the DOJ today, as they are taking a very careful approach. Thank you. Ms. Carmen Khan.
New Zealand's Evidence Act 2006 as its blueprint, yet deliberately omits several provisions. Where the bill departs from the New Zealand model and expressly excludes proceedings of cases concerning national security, how does this legislative approach embody the principle of maintaining Hong Kong's common law system under one country, two systems? And can we also hear a bit more about the implications and considerations for cross-boundary evidence scenarios involving the Greater Bay Area on maintaining a clear boundary between the two legal systems operating within one sovereign state? Thank you.
好，請專員回應。
多謝江議員個問題啦。
Thank you, Ms. Kong, for your question. If the chairman doesn't mind, I will reply in Cantonese. I don't mind that. The concern raised by the member is about the scope. Specifically, it would not apply to national security related cases, as well as how the bill has certain provisions will apply to cross-boundary issues such as those with other GBA cities. Let me first answer the second question. With the principle of hearsay evidence, for the declarant, where the declarant is not exactly relevant, whether the declarant is in Hong Kong or not, as long as in the criminal proceedings a party believes it is necessary to make use of this new mechanism to introduce hearsay evidence. Some conditions have to be met in order to do that. So, take my example from earlier. The declarant may not be in Hong Kong, but the same conditions would have to be met. Or at least the conditions applicable under the circumstances. As I said earlier, for example, the declarant is in Australia, certain conditions have to be met, and the threshold is quite high. It is only when the conditions are met the court will consider whether to introduce this hearsay evidence, unless the prosecution and the defense have agreed, and this essentially introduces a lower threshold. If there is agreement or if there is no objection, the hearsay evidence can be introduced. And if there is opposition, again, the courts will have regard to the criteria introduced in the bill to see if the opposition is to be accepted. I'm not sure if Ms. Kong was referring to how certain cases are excluded from the bill. Is my understanding correct? Right. My Solicitor General's understanding is correct. What the justifications for excluding certain cases. Right. Why the bill's provisions will not apply to national security related cases. Right. Thank you for the clarification. I did not hear quite well what was said earlier. I'm glad my understanding is correct. We have carefully considered the circumstances, and we have also consulted relevant departments on the provisions. We believe with the new mechanism for introducing hearsay evidence should not apply to national security related cases, because for national security related cases, the cases are complex and sensitive. And for, say, defendants and witnesses in the cases, the circumstances can be quite complex. If it is about safeguarding national security, we believe we should be even more prudent. We do already have some sort of a balanced approach with our existing provisions or with the provisions in the bill. After consulting the relevant departments, it is raised, and we agree that the relevant provisions should not apply to national security related cases, to adopt a more prudent approach to prevent people abusing this new mechanism to introduce hearsay evidence in national security related cases, not for the purpose of introducing hearsay evidence, instead to convey some incorrect messages. And with this, it will be very hard to reverse the approach. So we went along the direction of not applying the provisions of the bill to national security related cases. We believe it is more appropriate for the safeguarding of national security. Thank you. Any follow-up? None. Thank you. As explained by the Solicitor General, this exclusion for national security would only apply to prosecution and defense. It does not apply to specifically the defendant. So I think it's fair. Thank you, Chair. Your understanding is very much correct. Alright, I would like to speak myself. The DOJ has provided a comprehensive follow-up, provided some comparative analyses, as well as followed up on the reforms in New Zealand and what happened with the Singaporean and Canadian models. I have a very good impression of what is said in paragraph 19. I think that's quite interesting. For each common law jurisdiction, they have seen developments with their local characteristics, and we have also a case, Wong Wai Man, as well as a more recent case in 2025, Lee Chung Choi, with the Court of Final Appeal, that explicitly said exclusions for hearsay evidence in common law should be decided by the legislature and not the judiciary. I think in Hong Kong the developments in relation to hearsay evidence are very clear, and it is demonstrated in the bill as well as our earlier discussions, and I hope it will continue in our future clause-by-clause examination. So this is my observation. I also have a question. So New Zealand makes use of a balanced model, but they have also seen some developments after 20 years of implementation. I think with our bill, there should be room for us to build on top of this balanced model to make appropriate adjustments. If we look at the experience of other common law jurisdictions, say New Zealand and other locations, there are further developments. I would like a simple response from the Solicitor General on this. Thank you, Chair. I very much agree with your observation, Chair. For example, in the recent case of Lee Chung Choi, it involves some reforms for hearsay evidence in criminal procedure, and it talks about how the legislature should deal with relevant issues. I very much agree with what the chairman said. And it is indeed demonstrated by the introduction of this bill into the council for LegCo members to carefully consider the proposals of the government. The chairman's observation is in line with how the executive, legislature, and judiciary interact at this point in time. As for the chairman's second question, just as I said earlier in response to Mr. Holden Chow's questions, we have referred to the ARC's recommendations. We think the New Zealand model can be of good reference, but it does not mean we will follow everything. I already said this in response to members' questions, but basically the New Zealand model is more prudent and balanced. In future, there are ways for the government to follow up on the implementation of the bill subject to passage of the bill by the Legislative Council to see if the new mechanism is implemented in an ideal or balanced manner. If there's something we need to follow up on, or if we need to review, we will definitely do it. As I said earlier, multiple times, we have referred to practices of different jurisdictions, common law jurisdictions, as well as the different cases. The government, in particular the DOJ, would have the responsibility to continue to follow up on this.
好，咁
Right, thank you, SG, for the response. I think that's all for our discussion on the administrative response to issues raised last time. I see that no member has asked for a second round. Now let's see if there are further questions on policy issues. If so, the floor will be open again for these questions to be asked. If there are no more questions, we'll move on to the clause-by-clause examination. Right, I don't see any member wishing to ask further questions about policy issues, so let's begin the clause-by-clause scrutiny. Now, in the process, I would ask the legal advisor to raise questions if necessary. Now, members, if you have comments or questions, please also press the button to speak. I will invite members to refer to CB bracket 2810/2026, which is the blue bill, as well as the marked up copy of the bill that's prepared by the Legal Service Division of LegCo, CB bracket 3804/2026 bracket 04. So if there is no objection, according to practice, the Bills Committee will first consider the Chinese text of the bill. So would the administration please get ready and walk us through all the clauses? First, in relation to the long and short title set out in the blue bill, and then we can move on to the marked up copy. SG, who would like to lead this exercise? Chairman, I'm going to invite my colleague Ms. Heidi Lee to briefly introduce the content of the bill. Now, unless Chairman finds absolutely necessary, we're not going to read out each and every clause. So I'll give the floor to Ms. Heidi Lee. All right. We now look at C1224 of the blue bill, the long title. This is a bill to amend the evidence ordinance to provide for the admissibility of hearsay evidence in criminal proceedings and surrender proceedings, and to provide for related matters. There are three parts to the bill. Part 1, preliminary. Part 2, amendments to the evidence ordinance. That's the crux of this bill. Part 3, other corresponding amendments. Well, we now look at Part 2, or Part 1, preliminary, short title. This ordinance may be cited as Evidence Amendment Ordinance 2026, and it will come into operation on a date to be appointed by the Secretary for Justice by notice published in the Gazette. Please pause. Let's see if there are questions from the floor. Please continue. Clause 2. The enactment specified in Parts 2 and 3 are amended as set out in those parts. We now move on to Part 2. I will now invite members to check the marked up copy, CB bracket 3804/2026 bracket 04. We can look at the Chinese text. Let's begin. Page 1 of the marked up copy, amending Section 25, Government Chem Certificates. the schedule will be renumbered according to the bill. Schedule will become Schedule 1. So for Section 25, we're going to amend the relevant wording from Schedule to Schedule 1. There is no change in substance. It's just a renumbering of the schedules. Page 2 of the marked up copy, again, a corresponding amendment in Section 26 in relation to certificates as to photographic process. Again, the wording, the schedule will be amended to read Schedule 1. Page 3. After Part 4 of the Evidence Ordinance, we are going to add the new Part 4A. That is hearsay evidence in criminal proceedings and surrender proceedings. Part 4A will be divided into 6 divisions. Division 1 sets out the new 55C all the way to 55J. 55C, Interpretation Clause. Setting out definitions for terms used in Part 4A, I'm going to explain the interpretations. First, oral evidence. Oral evidence includes evidence that the person called as a witness gives in writing, by signs, or by way of any device by reason of the person's disability, disorder, or other impairment. And if this person is disabled or due to some issues, the evidence must be given with the aid of a device or gestures, then the evidence will still be regarded as oral evidence. Next, surrender proceedings means proceedings for committal under Section 10 of the Fugitive Offenders Ordinance, Cap 503, or an appeal under Section 11 of that ordinance. Statement means representation of fact or opinion, however made, including a written or non-written communication or non-verbal communication in the form of conduct that is intended to be an assertion of any matter communicated. Next, declarant. That is, the person making the statement. Hearsay. The definition can be found in 55D. Please continue. Page 4 of the marked up copy, 55D, meaning of hearsay. Now, a statement adduced or to be adduced in an evidence is hearsay if the following 2 conditions are met. First, it was made otherwise than by a person while giving oral evidence in court. Second, it is adduced or to be adduced to prove the truth of its content. Next, 55E. Please pause here. 55D bracket B. Why does it say a reference to hearsay includes hearsay of whatever degree? Chair, allow me to explain. Yes, please, SG. For clarity, we provide here the explanation to avoid unnecessary legal dispute. If hearsay evidence is to be adduced in criminal proceeding, there may be points relating to the specific circumstances of the hearsay evidence. For example, a declarant made a statement under certain circumstances. This statement may capture fact as well as opinion. So, regarding this statement, it may entail both or even more. Perhaps only part of the statement constitutes hearsay. So to avoid dispute, this declarant making a statement outside of the court may have done so comprising different aspects, including fact and opinion, and that the party wishing to adduce hearsay evidence may want to consider the degree to which hearsay evidence is included. So we want to capture that as well in the provision. Thank you for your explanation. In other words, we do not need to consider to what extent this statement constitutes hearsay. That is, be it in part or in whole, if the statement involves hearsay. Like the SG said, if this statement is to be relied upon, then regardless. And in order to avoid dispute in the future, the provision is phrased this way. Whether or not you're relying wholly or just partially the statement as hearsay evidence, we don't want to make a distinction, and that is why it's provided here that a reference to hearsay evidence includes hearsay of whatever degree, according to what's set out here. Your explanation, your understanding is correct, Chair. Let me also supplement. This is indeed our intention. We want to avoid disputes. But it doesn't mean that for hearsay of whatever degree it can be adduced easily. It's still subject to all the conditions in the mechanism. Mr. Wu Ying-pang. To follow up on the Chair's question, I'm looking at 55D, hearsay of whatever degree. So it's a matter of degree. My question is whether it will capture 55Y as well, and that's about multiple hearsay. As I understand, these are two different concepts. 55D refers to the degree. 55Y refers to multiple layers of hearsay. So I'd like the SG to clarify this. SG? Thank you, Mr. Wu, for the question. Now, I think Mr. Wu's concern is whether multiple hearsay in 55Y will be captured by 55D here, hearsay of whatever degree. In theory, the answer is in the affirmative, because hearsay of whatever degree also includes multiple hearsay. That is, the declarant of the statement did not utter the words according to their own observation. But I'd like to allay the concern of the member that even for multiple hearsay, it will not be adduced easily through 55D. This is exactly why we have provided a 55Y as well. The purpose of this provision is to impose a condition on multiple hearsay, and that is for every layer of the hearsay evidence in a multiple hearsay situation, all the conditions must be met layer by layer, and it's not as easy to be adduced. Yes, please continue, Ms. Lee. We're on page 455E, application of the new mechanism. Subsection 1 sets out the legal procedures applicable. It should be read with subsection 2, and that is, on the face of it, the proceedings may be captured by subsection 1, but if it also falls under subsection 2, then it should be disapplied. Now, for 55(1)(a), the mechanism applies to or does not apply to sentencing in a criminal proceeding or surrender proceedings, the strict rule of hearsay still applies. The next part is hearsay evidence adduced by the prosecution to prove a disputed aggravating factor.
用即係所謂
In subsection 2, there are some exclusions where this part does not apply. Basically, in what is said in A, B, C paragraphs, say in A, being information furnished under Section 27 of the Organized and Serious Crimes Ordinance or under an order of the court. B, hearsay evidence adduced or to be adduced by the prosecution in criminal proceedings in respect of sentencing to prove an undisputed aggravating factor. And C, hearsay evidence adduced or to be adduced by the accused in criminal proceedings in respect of sentencing to prove a mitigating factor. There is another category that can be excluded, which are set out in paragraphs D and E. D, hearsay evidence adduced or to be adduced in proceedings of a case concerning national security, and E, hearsay evidence adduced or to be adduced in proceedings commenced before the commencement date of this part. Excuse me, can you pause here? Mr. Wu Yingping would like to speak. Thank you, Chair. We should follow the Safeguarding National Security Ordinance and Section 47 of National Security Law and Section 115 of the Safeguarding National Security that we have to have the Chief Executive issue a certificate for a national security case. So should we make clear here we also need a certificate from the Chief Executive, or will the court be able to reach a conclusion themselves? Thank you. Solicitor General, thank you. Chair, thank you, Mr. Wu, for the question. We understand where Mr. Wu came from, but for 55E2D, it talks about a case concerning national security. With this expression here, it is followed by a bracketed expression that says, within the meaning of Section 3.2 of the Safeguarding National Security Ordinance 6 of 2024, and in a specific provision in the Safeguarding National Security Ordinance, there is a definition. It will clearly define what a case concerning national security is. As for what Mr. Wu said earlier, with the Chief Executive having to issue a certificate in a piece of recently promulgated subsidiary legislation for the Chief Executive to confirm whether a case is a safeguarding national security case, it does not affect the operations of our professions here, because we are operating on the relevant provision in the Safeguarding National Security Ordinance. Thank you. Ms. Christine Fong. Thank you, Chair. I want to ask about 55E A. I believe it's 1A, regarding adducing hearsay evidence in surrender proceedings. Let me give you an example. If we have some proceedings that should take place in Taiwan and the proceedings cannot go on, and the criminal is in Hong Kong. If we want to adduce hearsay evidence here in Hong Kong, can it be done? Solicitor General, thank you. Chair, thank you, Ms. Fong, for the question. Let me provide greater detail with evidence to be adduced in surrender proceedings, or what circumstances will invoke this particular scenario. I will provide some examples. Let me first talk about the background. For surrender proceedings, in local court proceedings, some parts of the process will have the strict rules of evidence apply. What does this mean? Say, for some foreign jurisdictions, they have an agreement to surrender fugitives. So say if the other jurisdiction wants Hong Kong to surrender a fugitive, and the law enforcement agencies in those jurisdictions will provide some evidence for the judiciary's reference, and we have our own process in the courts of Hong Kong, so that for a fugitive to be arrested and brought to a court in Hong Kong, specifically a magistrate's court, with this process, the strict rules of evidence apply. In those proceedings, the DOJ, who's not the prosecution in the specific process, the DOJ would have to put some evidence before the magistrate with reference to the evidence produced by law enforcement agencies in other jurisdictions. For example, the police officer who made the arrest would have to give evidence in court to say this person is the arrested is the fugitive. And if under some special circumstances hearsay evidence has to be adduced, this provision would apply. In fact, for this scenario, the Law Reform Commission considered this specifically. We also consulted the relevant departments, and this is the approach we will take in future. Yes, Ms. Christine, follow up? Yes. Well, if the fugitive wants to plead guilty, is there any way we can deal with that in Hong Kong? Say for hearsay evidence, if we have in a criminal case, say murder, we have some blood-deed prints, DNA evidence, can we have such evidence transfer to Hong Kong and we can deal with those cases? Well, before I ask the Solicitor General to answer the question, there's no intention or any way to make changes to the Fugitive Offenders Ordinance, right? I think the Solicitor General can make clear with surrender proceedings, how we can adduce hearsay evidence before the magistrate. Thank you. Solicitor General. Thank you, Chairman and Ms. Fong, for the questions. The Chairman's understanding is quite correct. To answer Ms. Fong's question, as the Chairman correctly observed, and I want to explain, we are only amending some rules of evidence in surrender proceedings. It will not affect at all the requirements and operations of the Fugitive Offenders Ordinance, Chapter 503. With our provisions here, it only deals with where the strict rules of evidence apply, and as in the example I gave earlier, the police officer, for example, who made the arrest, could not give evidence in court. The hearsay evidence can be adduced. To answer Ms. Fong's question, for the fugitive that has been arrested, for the fugitive's plea, it will not be dealt with in courts of Hong Kong. Even if the fugitive plans to plead guilty, the courts of Hong Kong cannot deal with that. Alright, I have a question. Can you give an example of what a disputed aggravating factor is? According to here 55E1B, this part applies if the aggravating factor is disputed. If it is undisputed, it will not apply. So can you give some examples? Alright, I will ask my colleague to give some examples. Mr. Jonathan Mann, can you turn on the microphone for Mr. Mann, please? Thank you. I think we can think about a hypothetical scenario where the defendant has committed similar offenses, or they have some conviction records, and the defendant disputes the relevant records. The prosecution would have to prove that the defendant has committed certain offenses, or indeed has some of such conviction records, and the defendant or the defense would have to be disproved, basically, or discredited. So this is what happens when the aggravating factor is disputed. Alright, please continue. We are still at 55E. Now we're moving on to subsection 3. We talked about for proceedings that have commenced, this part would not apply. So here we specifically talk about when proceedings are regarded as having been commenced. In paragraph A, for criminal proceedings for an offense in respect of which a complaint is made or an information is laid at the time when the complaint is made or the information is laid. B, for criminal proceedings for an offense in respect of which an indictment is preferred under Section 24A1B of the Criminal Procedure Ordinance at the time when the indictment is preferred. C, for criminal proceedings in respect of sentencing at the time when the criminal proceedings of which the sentencing proceedings form part are commenced. Or D, for surrender proceedings that relate to a request for the surrender of a person to a place outside Hong Kong at a time when a warrant for the arrest of the person is issued by a magistrate under Section 7 of the Fugitive Offenders Ordinance. Basically, subsection 3 is how For the 3 subsections, it is where the part would apply.
Right, then can you confirm this? For subsection 3, it refers to proceedings commenced or criminal proceedings commenced. Basically, subsection 3 captures the various kinds of criminal proceedings. Yes, Chairman, I can confirm your viewpoint. These are all captured by this subsection. Right, on to page 655F of the marked up copy. This is adaptation or interpretation clause relating to surrender proceedings. In relation to the person to be surrendered, prosecution, we need to make use of these references to terminology to make sure that they apply to the surrender proceedings. 55G. For common law rules governing admissibility of hearsay evidence to which this part applies abolished. The common law rule governing hearsay evidence to which this part applies in the proceedings described in 55E1 other than those preserved by 55V are abolished. Right, next 55H, page 7. Implied assertions. There is a common law rule to treat implied assertions as hearsay, and here the common law rule will be abolished as well. 55I, admissibility of hearsay evidence and the legal grounds. For hearsay evidence to which this part applies is admissible in the proceedings only if it is admissible under 3 circumstances. A. Divisions 2, 3, or 5. B. A common law rule preserved by Section 55V, and C. Any other enactment. 55J. This part does not affect any power of the court to exclude evidence on grounds other than that it is hearsay. Right, that's all for Division 1. I see Mr. Alex Fan would like to speak. Right, thank you. I want to go back to 55H and the relevant provisions in relation to the implications of the common law rule on hearsay evidence. In particular, my question is about, say, the regeste principle. This is a common law exception. Does it mean that according to the provisions here, this common law rule will be abolished as well? SG. Thank you, Chair. Thank you, Mr. Fan, for the question. Mr. Fan refers to a common law exception. It will be preserved according to Schedule 2. It's in fact under point 7 of Schedule 2. And that is, well, I don't know whether this is Mr. Alex Fan's concern. Res geste. Right, let's take a look at 55V, and that's page C1267 of the Blue Bill. When the administration explained 55G just now, they referred to the common law rules governing hearsay evidence which will be preserved under 55V, and the rest will be abolished. So perhaps the administration can walk us through 55V as well. Yes, Chair. I agree with your suggestion. We should first look at 55V now. Ms. Heidi Lee just now read out a provision that is about preserving common law exceptions. and that's 55G. And as per Chair's observation, there is reference to 55V. Let's turn to 55V then. 55V provides the common law rules set out in Schedule 2, which are preserved. So we add Schedule 2 to preserve common law rules relating to exceptions to rule against hearsay. And then if we go to Schedule 2 altogether, there are 8 rules. Earlier, I already explained to members that for these exceptions of common law to be preserved under Schedule 2, the LRC considered in great detail before coming to this decision. We have not made any change to the LRC's recommendation. Mr. Alex Fan just now asked about res gestae. That's Rule 7 of Schedule 2, in fact. So this will be preserved. Now, coming back to 55V, this is a very clear provision. The common law rules set out in Schedule 2 are preserved. If I may ask members to go back to 55G. Read together, apparently, the common law rule to exceptions to ruling against hearsay will be preserved in Schedule 2. Other than that, for other common law exceptions, they will be abolished according to 55G. That's the background of our consideration. They should be read together, the provisions as well as the schedule, or Schedule 2, Mr. Fan. So if I have questions about Schedule 2, should I ask now or? Well, if you're talking about Rule 7, res gestae, if you have concerns, then do raise them. No, I have no follow-up on this point. We're on 55I. I'd like to say this. The 55I refers to exceptions and how this is included in this bill. That is, hearsay evidence will only be admitted under the following circumstances. That is, only if these circumstances arise, including the common law rule preserved in Schedule 2, as well as Divisions 2, 3, and 5, or any other enactment. We'll go through them in a moment. Am I correct in saying that? Yes, it's correct. Well, let's go to 55J, shall we? Yes. We want to expressly provide that in relation to this hearsay evidence admissibility mechanism, it will not affect any power of the court to exclude evidence on any other ground. Well, the court may exclude hearsay evidence under the current laws in the criminal proceeding. At the same time, the court has the power to exclude evidence for failure to meet other legal requirements. For example, if the evidence is totally irrelevant to the case and that there is no relevance to the case at all, which is a basic requirement, then of course the court may rule this out. Another example, the court has the general power to rule out certain evidence. It may not be hearsay evidence, but say the court makes first-hand observation about the witness making or giving evidence in court, and the court is of the view that this evidence may cause prejudice to the defendant, and the prejudicial effect outweighs the probative value of that piece of evidence to an extent that the court may exclude the evidence under common law. For the exclusionary power to be exercised by the court, it handles evidence in general and not just hearsay evidence. We want to provide expressly that this power will not be affected here. Mr. Alex Fan. Right, I have a question on 55J. I'd like the Solicitor General to explain the following. Does it mean, for example, after passage of the bill, if hearsay evidence is admitted by the court under Divisions 2, 3, and 5, then according to 55J, the court will still have the discretion to exclude that evidence. SG. Thank you, Chair. Thank you, Mr. Fan, for the question. 55J spells it out. If the court excludes a piece of evidence on grounds other than that it is hearsay, then such power will not be affected by the bill. We just want to spell it out. About Mr. Fan's question, if I get it correctly, I think your understanding is correct. Now, if the evidence does not involve hearsay and the court is not considering exclusion of the hearsay evidence, then this power will not be affected by the bill. Next, Division 2, there's only one new section, 55K. That is, if both parties agree hearsay evidence is admissible in proceedings, as follows. Subsection 1. Hearsay evidence is admissible in proceedings if the prosecutor and the accused for or against whom the hearsay evidence is to be adduced make an oral agreement before the court for the admission for the proceedings, or produce a written agreement. Subsection 2. An accused oral agreement or written agreement can be made by the accused or the accused's counsel or solicitor on their behalf. Subsection 3 refers to the written agreement to be signed. Subsection 4. Hearsay evidence admissible subject to agreement by both parties or at the party, then it could only be adduced by that party, prosecutor or the accused. Subsection 5. The agreement can be used for subsequent proceedings relating to the matter, and with the permission of the court. In the original proceedings or any subsequent proceedings, the agreement may be withdrawn. Subsection 6 refers to subsequent proceedings, including the appeal and a review in respect of the same matter. However, it does not include a retrial or further trial of the matter. Subsection 7 provides for a definition for the term review. That means a review under Section 104 of the Magistrates Ordinance or Section 81A of the Criminal Procedure Ordinance Cap 221. Please pause here. You've gone through a big part here, Division 2. Let's see if there are questions arising from Division 2.
又或者我自己提一個
Or I have a question myself. For subsection 6 and 7, specifically subsection 6, why do we exclude a retrial or a further trial of the matter? Solicitor General. Thank you, Chair. I will explain this. With this provision, with the agreement of the prosecution and the defense, hearsay evidence should be able to be adduced, but for some reason, if a retrial or a further trial is needed, we would regard that as a trial anew. So for agreement made to adduce hearsay evidence, it is inappropriate for it to be binding on the retrial or further trial. The prosecution and the defense should revisit this. That is, the prosecution and the defense may consider whether to make another agreement, and we want to not rule out this path in law. We believe this is a more prudent approach. Thank you. That is a very clear explanation, Ms. Christine Fong. Thank you, Chair. I want to follow up also on subsection 6. If we do not include a retrial or further trial of the matter, it would mean at some point there was agreement to adduce hearsay evidence. Well, the speaker's microphone is not on. Please turn on the microphone for Ms. Fong. We have many procedures that would require the submission of papers, say for preliminary hearings. It can be quite troublesome, lengthening the time for hearings. But of course, we want to be fair, and I support this bill. I just think if you say you will not include a retrial or further trial of the matter, are you saying you will exclude hearsay evidence altogether with retrials and further trials? Solicitor General, I want to clarify something. When we say here it does not include a retrial or further trial of the matter, we do not intend with this to say hearsay evidence cannot be adduced in retrials or further trials. It is just that at the first trial, perhaps the prosecution and the defense agreed to adduce some hearsay evidence, and this case later on has to be retrialed or has to have a further trial. This agreement will not be binding in the retrial or the further trial. The prosecution and defense may reach another agreement to adduce hearsay evidence. We just think in retrials or further trials, the prosecution and the defense can revisit this. It's not that they cannot adduce hearsay evidence altogether. And I think we should think about how here in subsection 6 it says, for the purposes of subsection 5 and a reference to subsequent proceedings relating to a matter does not include a retrial or further trial of the matter. It does not mean prosecution or the defense cannot adduce hearsay evidence in retrials or further trials. Yes, Mr. Holden Chow. Chair, I have a question. If the two parties agree to adduce hearsay evidence, it can be oral evidence or it can be written evidence, right? But in actual operation, when we represent defendants, very often the counsels from the prosecution and the defense will communicate to reach certain agreements. But let me say this. When it happens, it's often for the more minor matters. I think with a written agreement, it would be more prudent. We would talk about how we have exchanged bundles and what we know, what we agree on, what we don't agree on. If we allow oral agreements, I'm not saying oral agreements should not be accepted, but of course written agreements will be more prudent. It will show the counsels have received clients' instructions. Of course, lawyers would only see if they will agree to the relevant arrangement after having the client fully understand the situation and having received the client's instructions. But I think whether to accept hearsay evidence is quite an important matter, and we should consider whether oral agreements would be appropriate. We can allow for oral agreements, but I think if possible, written agreements should be used by the counsels. This is what I experienced in actual operation, so that's why I have this question. Right, so for 55K1A, whether the agreement can be oral, whether there should be just a written agreement before the court. Solicitor General, thank you. We understand where the member came from. We very much agree we need to be prudent. With the agreement to adduce hearsay evidence, it is important. We propose to allow for oral agreement, but it does not mean people can go willy-nilly with the making of agreements. After careful consideration, we want to strike a balance by having the oral agreement made before the court. So during court proceedings, the judge, if they have observed the agreement is not written but oral, it must be made before the court for this very reason. We believe the court will deal with this very carefully. We have considered different scenarios, including the scenario where both parties are represented. We have also considered how one may be unrepresented, which is why we considered oral agreement should be made acceptable. And if we look closer at the design of 55K, specifically subsection 5, it spells out how the agreement may be rescinded with the court's approval, of course. and it can be withdrawn by one of the two parties. There's no agreement needed. We believe it is an additional safeguard available. We believe with these in mind, in the design of the provision, allowing oral agreement before the court would be appropriate because for some cases, if it is found there is a need to adduce hearsay evidence, and when it is not exactly appropriate to adjourn the case for this very purpose, because it would take some time to deal with this with the written agreement, oral agreements would be more efficient. We do understand a member's concerns. We believe what we have is a prudent approach. Mr. Holden Chow, thank you for agreeing with me. I agree with you, actually. We should consider those who are unrepresented. Alright, thank you. I can see Mr. Wu has some questions. We are at Division 2. I'll extend the meeting by 15 minutes. If there are further questions on Division 2, we will consider them now before ending the meeting. Yes, Mr. Wu. Thank you, Chair. My question is about 55K6B, where it should not include a trial or further trial of the matter. I get why you want to exclude a further trial, but then for a retrial, it's often regarded as a continuation of the same case. If we exclude the agreement, will it essentially refers what one side admitted earlier, causing unfairness? I will ask my colleague Mr. Mann to answer the question. Thank you for what is said here. Retrial and further trial, they are similar. For retrials, say if one has appealed successfully, the case will have a retrial. It would basically mean the proceedings would start from scratch. If it is jury trial, there will be a new jury. Well, there are some cases where there are no appeals, or when the jury has not reached a majority verdict, the jury has to be dismissed. Alright, this is a retrial. What I said earlier was for a further trial. So it is kind of like a retrial where the proceedings also start anew. For a retrial, it is not bound by the agreement. The same logic applies. Alright. Thank you, Professor Alex Fan. Thank you, Chair. Can I invite the Solicitor General to elaborate on subsection 4? I think I understood him. I just wanted to check if my understanding is correct. Basically, if we have more than one defendant in a case, say the first defendant signed an agreement and the hearsay evidence adduced would only be admissible against the defendant, not the other defendants. I want to confirm if this is the case. I also want to ask about 4A and B because it says and between paragraphs A and B. When you say by the prosecutor or the accused and for or against the accused, it can be somewhat confusing. If it is introduced by the prosecutor, it should be unfavorable against the accused. But I think it's conveying a different meaning here. Thank you.
Mr. Mui, thank you, Chair. Thank you, Mr. Fan, for the 2 questions. I'll try to take them. The first point is actually a comment. Mr. Fan's understanding is absolutely correct on subsection 4, and that is the agreement only applies to the accused as privy to the agreement. For the other accused in the case, not privy to the agreement, the accused will not be affected. So Mr. Fan's understanding is correct. The second question relates to for A and B. And the consideration. I can ask my colleague to supplement if necessary, but let me explain that is so worded to capture different combinations. For hearsay evidence to be adduced by the prosecutor or the accused in the proceedings, at that stage, we cannot determine whether the hearsay evidence is or is not prejudicial against the accused, and that is why we want to take a broader approach by capturing different combinations. I'll give the floor to the drafting division. Ms. Lau? Yes, I agree with Mr. Moy because we cannot rule out at that stage whether the evidence to be adduced by the prosecutor is for or against the accused. The focus is on the hearsay evidence being relevant to the accused adducing the evidence and not the other accused. Right. In other words, can I use the same example? Let's say the prosecution enters into an agreement with the first defendant. Then, for the evidence to be adduced, be it for or against the first defendant, both parties are free to use the evidence. Thank you. Mr. Fan's understanding is correct. I don't see any further questions or comments from members on Division 2. Now, we're supposed to adjourn the meeting at 4:30. I extended the meeting to 4:45, but for completeness, I think we should start Division 3 next time. All agree? Yes? Now, in relation to the parts already covered, if anyone would like to move any amendment, please provide the proposed amendments in both Chinese and English to the Secretariat for handling as quickly as possible. As for the next meeting, I will discuss with the administration about the schedules, and then I will invite the Secretariat to issue notice to members. I thank the administration for attending, and I thank members for coming as well. Let's see if there is anything under AOB. If not, the meeting ends here. Thank you.